welcome you, ma'am. Okay.
Okay.
So, hello.
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 So, sir, can
Yeah.
I start?
Yeah.
So, okay. Good evening, everyone. It is my pleasure to welcome the speaker for today's section, Ms. Dhanya Ramachandran, patent analyst at Prasannan Associates, Kochi, to speak on patenting system and filing procedure. Her experience in patent analysis and intellectual property rights will provide us with valuable insight about this area. So, let welcome Ms. Dhanya Ramachandran for this section.
Thank you, Ms. Jyotsna. Thank you for your welcome. So I'm Dhanya Ramachandran, and I'm a patent agent working as a patent analyst with my firm. I'm working at Prasannan Associates. This is a firm which has head office in Chennai, and we have branches in Trivandrum, Kochi, and Bengaluru. So I'm sitting at Kochi office. So that's it about me. And we are basically catering exclusively. We are actually a law firm, but catering exclusively to intellectual property law related aspects. So maybe I'll just jump into the session now. Am I audible to everyone?
Yes, madam, you are audible.
Yeah, I hope everyone can see the screen. So I'll be dealing with patent filings and procedures under the Indian patent law. So my colleague would have already covered some of the aspects of the patent. Why you should file a patent, what are the criteria to get a grant. All those things my colleague would have already covered. Some of these slides might seem repetitive to you, but I think since I'm covering patent filings, I have to still say all these things. I hope most of it won't be repetitive, but still some of you might feel some of the slides could be repetitive.
Madam, that is fine because repetitions makes things concrete in mind.
Okay.
It is fine. Okay.
Thank you, sir. Thank you. So coming to the introduction part, this is something you might have already heard. So what is a patent? A patent is basically an exclusive right. It is a monopolistic right that is granted by a government for an invention that you have developed. And inventions are, which it is not. It is an invention which should be novel and inventive. Should be a solution to a technical problem. So patent is basically giving you a monopolistic right for a novel and inventive solution to a technical problem. So maybe you can think about it like in olden days, if you have to climb a coconut tree, usually somebody has to use ropes and all to manually climb the tree. Now there are many machines which help anybody to climb coconut tree. So those are innovations, which helps in solving a technical problem. So initially only a skill set of people could do it. Now you are bringing in a broader base of people who can do the same thing. And probably, if you have a large land of coconut plantation, then such innovations will help you. Especially nowadays we have problems like labor shortage and all. So such innovations which I mentioned now will help you in many ways, reduce the cost of labor, improve the ease of harvesting and all. So it is just one example that I have taken. So what is the importance of patent? So why is it important? Why should you file for patents? So it basically, whenever you have some innovations like this, and if you get a patent and you can monetize it and benefit from it, monetarily as well as other ways, you are you will be getting credits for inventions, which actually makes all of us feel good and better, right? So it basically encourages innovation. Unless you incentivize creators of inventions, you will never it will be difficult to encourage such innovation. So granting patents for such inventions will encourage innovation. It will provide legal protection. So when you have come up with something that has some impact, in a certain area, you also want to protect it so that you can benefit out of it. So getting a patent for your invention will give you legal protection, and it also gives you exclusivity in market. So again, if you come up with an invention and you have not applied for a patent, then you do not get this exclusivity. Somebody else can copy what you have already created, and they can also make money out of it. I'm not saying nobody should make money out of it, but someone who has spent a lot of time, money, and so many other resources, probably if you look at coconut climbing machine, it may not look like much to you, but think of innovations or inventions like a pharmaceutical drug. So pharmaceutical drug takes a lot of effort to to bring one drug into the market. Takes an immense amount of effort, not just monetary effort. It takes human effort. It takes infrastructure. Some drugs are brought into market spending more than GDP of many countries. So think of if you don't give patents to such inventions, who will come up with drugs for other diseases? So unless you give exclusivity in market for inventors, for a certain period of time, so that nobody copies, they get legal protection, and you don't have, you don't incentivize creators to come up with new inventions, so that we can all, human beings can enjoy the benefits of technology. So basically, in the Indian patent law, it is governed by the Patent Act 1970, and it is also governed by the patent rules. This Patent Law Act, I'm sure all of you know, an act is something you can amend only through the proceedings in the parliament. Whereas when it comes to rules, there are certain authorities, bureaucrats, who can make amendments to the rule. So act usually provides, the basically contains sections where it is clearly stated what are the regulations with respect to here granting a patent, who is an inventor, who is an applicant, what is anticipation, those kind of things I'll come later. But basically, Act gives you an outline of that, and rules will give you an outline on what is the procedure for doing various activities within the Act. So that is what the rules does. Rules can basically be amended. In fact, rules often get amended. At least once in a year, we are getting amendments nowadays. So at least for past 5-6 years, we are getting some kind of amendment rules. So rules are basically amended for many reasons. So if you look at the reasons why the rules were amended in the past few years, it is basically to improve the ease of doing business in India, improve the ease of to reduce the bureaucratic red tape. So there are many amendments which has considerably reduced the difficulties in filing a patent, getting a grant, and many things. So now, because of certain amendments that has been brought about in the recent past, the number of filings in India coming from foreign foreign countries have also increased, because the ease of doing things, ease of getting a grant has improved basically. A patent office it is basically, it comes under the Department for Promotion of Industry and Internal Trade, which also comes under Ministry of Commerce. So patent office, I am sure my colleague would have said, is situated in the 4 metros: Delhi, Kolkata, Mumbai, and Chennai. And based on where you reside or which attorney service you are taking from, where the address of service is, or where the address of residence is, based on that you have to choose a certain patent office. Let us say, I am applying for a patent. I cannot apply it in Mumbai because I reside in Kochi. So I have to apply it in Chennai only. So basically, each jurisdiction oversees the filing and other related aspects of certain states. Like Chennai oversees the filings and patent related procedural activities from Kerala, Telangana, Andhra, Karnataka, Tamil Nadu. So basically, you can guess which other where the other office jurisdictions will be based on that. So basically, that is it. So patentable inventions under Indian patent law. So
Madam,
yes.
excuse, are you moving any slides?
Yeah, you can't
but-
see.
No, madam, we are only in the title slide.
Oh, I'm so sorry. I'm moving slides, so
Okay.
I don't know. Let me.
I hope you have shared the entire screen.
I have. Can you see something now?
And now the title slide is there.
Okay.
Can you try to move that?
1 second.
Or you put the slideshow? Which slide are you seeing now? Yeah, now introduction to patents.
What about now?
And now also introduction to patents.
Not sure what to do then. Can you help me?
Madam, can you share the PPT?
Yeah.
Ashwin, are you there? Ashwin, are you there? Hello, Ashwin. Okay, then ma'am, you please share to me, to my WhatsApp number.
Can you see now? No.
Now it is not coming, madam.
Okay. To your WhatsApp number is
Yeah,
it?
yeah.
Okay, once again. I'm sorry. I was not aware that slides were not moving. I have shared the slides. Can you see? Did you get it, sir?
Hello, madam, is the slide visible now?
I can see.
Okay. So now you are in which slide?
I was in the next slide.
Yeah, this one?
Yes.
Okay.
Thank you. So patentable inventions under patent law. This one also you would have covered, heard from my colleague. So basically, for a invention to be eligible for patent, it should be novel, it should be inventive, and it should have industrial applicability. So, what is novelty? What is inventive step? What is industrial applicability? Can anyone recollect from your previous presentation? Uh, is this an interactive session or sir?
Yeah, it is an interactive session.
Okay, can someone say? Okay, so novelty is like just the word suggests, it should be new. The invention should be new, should not be disclosed in any documents, or should not be in news, or basically that's it. Should not have it should be new. It should not have been used publicly, or it should not be disclosed in any documents. It could be patent literatures, it could be not non-patent literatures, could be any kind of document. So that is what novelty means. And novelty is an absolute requirement. Without novelty, you cannot expect patent, a grant for a patent. Next comes the inventive step. Inventive step is, what happens is sometimes you might find novel inventions, but you may not, these inventions may not have inventive step. So what is inventive step is something that is defined in the patent law. Patent law states that inventive step is something, when an invention has advanced in a certain state of the art, like currently we have a state of the art, and then you have made some advancement, and this advancement is non-obvious, and it should have some technical advantage, should solve a technical problem. If it process all these check marks, then it is inventive. So I'll give you a very simple example. So let us say, lemonade. All of you know lemon juice. You can just make it by having lemon juice, sugar and water, right? Let us say that was comparative. This is a comparatively, new invention. Nobody had, used it, but it is there now. It is people are using it. But let us say now suddenly someone made something similar with oranges. So what happens is, orange and lemon comes from the same family. Mixing it with sugar and water becomes obvious, even though nobody has, made something similar with oranges. When someone makes it with oranges, for a first time, it becomes obvious because lemonade is already there. I hope this was a simple example. So basically, that is what is what non-obviousness means. Then industrial applicability is something that is a criteria in India. In many other jurisdictions in the world, it is a much more it is not as strict as industrial applicability. It can be utility also. There is a difference between utility and industrial applicability. Industrial applicability means it has to be used in an industry, or it should be used in certain processes in the industry. Either industry should make the product, or the process should be used in an industry. So that is what an industrial applicability means. Utility is much more simpler. It just needs to be useful. Need not be manufactured in an industry, or need not be used in an industry. So basically, these are the three criteria, and globally, these three criteria, either in a lesser form or a stricter form like this, is present in all the jurisdictions in the world. And novelty is an absolute criteria which is common all over the world. So in India, if you look at the Indian patent law, it also says that even if an invention is novel, inventive, and industrially applicable, if the invention still comes under certain category of inventions that falls under sections 3 and 4 of the Indian Patent Act, then it becomes a non-patentable inventions. So some examples of these are, mathematical methods. You would have, you know, uh, come up with a mathematical formula which does a certain something, but such mathematical methods are not considered inventions because they are considered abstract. Business methods are also not considered inventions. Computer programs per se are not considered inventions. Then discoveries are not considered inventions. Then inventions which relates to plants or animals, plant parts or animals are also not considered inventions. So there are several clauses under section 3 which tells what are not inventions, even if it covers it, even if it is novel, inventive, and industrially applicable. So can we move to the next slide, sir? Okay, so patent filing process in India. That is the next slide. So let us say you have you have developed something and you think it is patentable. So what to do? So before filing, there are certain considerations you should have. Pre-filing considerations. What should you do? So you might think that your invention is new. You may also think it is inventive, but unless you look into the patent databases and non-patent databases, you cannot be certain about it. In fact, if you ask me, even if you look at these databases, you can still not be 100% certain, because the database is so huge, so extensive, so humongous. Because these are considered on a global level. Any document anywhere in the world can kill novelty and inventive stuff. So basically, we will be able to look at only patent and non-patent databases which is available online. So if you can find something similar or same invention, then you have to do a search, because most of you must know that patenting process is a slightly expensive affair, and it also consumes a lot of time. So before you spend all those time and money, you have to make sure that it's worth spending that time and money. So you can do a patentability search or due diligence, where you will be looking at similar inventions, whether such inventions, similar inventions, which can kill the novelty and inventive step aspect of your invention is already out there. Because if you can find that something similar is out there, then you need not waste your time and money on that. Or, for researchers also, if you can find something similar, you need not reinvent the wheel. You can move forward and do something, incrementally invent something, to the existing prior art. So those are things you have to think about before you go for a patent. Also, even before you do that, you have to have confidentiality agreement. So let us say you are a firm and you have come up with something and you want to file a patent. Or you want to disclose it with to your investors or somebody. So what do? You have to be very careful when you disclose inventions, because there is a chance that someone interested might copy it, and once it comes into public domain, even you cannot have novelty for your invention, because if someone already comes up even before you file it, or someone files it before you can file it, then either the invention will go from your hand, because if someone else gets a patent for your invention, then even you cannot use it, because it becomes their exclusive right. So these are things that you have to be very careful. before you disclose your invention to anybody. So confidentiality agreements, non-disclosure agreements, non-compete agreements. These are some of the kinds of agreements that you come into with other parties to safeguard your invention. Also, when if at all someone copies your invention and you have to go to court to settle such matters, the court will always look at how responsible were you in safeguarding your invention. What are the actions and measures that you have taken to safeguard your invention? So if you can prove to the court that you have made such agreements, you have taken certain actions to make sure that your invention is safeguarded, then it becomes a advantage to you, because the court understands that you have taken initiative, you have spent money, you have spent time to safeguard your invention. Then, determining the scope and protection that is needed. So once you have an invention, you have to understand what is the scope of your invention, what is the protection that you need. So scope and protection basically means, let us say you have come up with an invention on your dumb phone. So most of us have, migrated to smartphones. There are many who still use it. I know those not so smart ones, dumb phones basically. So let us say someone has come up with an invention in a dumb phone. So what do you do? If you ask me, there are many countries which still rely on such phones rather than smartphones. So you need protection in such countries rather than in technologically advanced countries. So that is what you mean by scope of protection, and what kind of protection is needed. Sometimes what you need may not be patent itself. It could be a design. What you have come up with could be a design. It could be utility patents. Utility patents are not something that India does not have such a system, but there are many countries which has such systems. So based on what is your invention, where your market lies, you have to determine what is the scope of protection that is needed for your invention. And filing a patent application. So basically, in India and some countries, we have something called a provisional specification and the complete specification. That is basically the technical disclosure that you submit along with your application, provisional and complete. So what is provisional, what is complete? So let us say you have an invention and you have not entirely finished work on it. Your prototype is almost ready, but you still have some more work to do, but you know where you're going. So that is a time when most of us working in this domain will suggest that you should apply for a provisional specification. You should apply for a patent with a provisional specification, because at that point of time, securing a date is very important. As I said earlier, the novelty, inventive step, and industrial applicability. These are, the points. Like let us say you have applied for a patent, an examination is done to check whether it overcomes these novelty, inventive step, and industrial applicability criteria. So how is it done? Of course, they'll look at patent and non-patent databases. But I know what is the primary main consideration here is the date of disclosure. The date of disclosure is very important. If you disclose an invention today to the patent office, then they will look at all the documents that has been in the public domain till today. They will not look at any documents. Examination may happen after 1 year. They will not look at any document that was published after this date. So that is a very important criteria, because there could be someone else who might have come up with something similar after that date. So it does not become a valid prior document for your invention. So to secure that date, could be, I know, to apply for a patent first as soon as possible. Applying with the provisional specification will help you. So this is basically what you mean by securing a filing date, so that when the application is examined, you will get an earlier priority date, and your application will be examined only based on documents that were published before the filing date. Now, complete application is something, even if you have submitted a provisional specification, you still have to file a complete specification, because unless you file a complete specification, none of the patent offices, will look at your document. Because complete specification is where you will be disclosing your entire invention. You will have your claims. I'm sure all of you will know by now what claims are. So the claims will be only, most present in the complete specification. You are claiming what you have invented. So that claims part is very important. So that is something you will find in the complete specification. Mostly provisional specifications will not have that. And complete specification will also have the experimental data to substantiate your claims. So if you have claimed something, you should also give proof to substantiate your claims. Those experimental data will also be present in the complete specification. So basically, while filing a patent, you have to decide whether you want to file with a provisional specification or with a complete specification. Then some of the most important forms that you will be filing along with your application is Form 1. Form 1 is the form which, basically is the form for applying for a patent. Form 1 has many details like, the name of the applicant, name of the inventor, their nationality, their addresses, and their affiliations. Then, the title of the invention, if there is any priority other than your invention may not be the first invention, there could be priority. So those details are all present, are all something which you will be filling in the Form 1. And Form 1 in India also has this provision to provisions for inventors to assign their rights to the applicant. So who is an applicant, who is an inventor? I'm hoping you will all know by now. But still, I'll just give a passing reference. The applicant is the actual owner of the patent. So basically, applicants can be individuals. Applicants can also be entities such as your college or a research institution or a company or a firm. Applicants can be entities also like this. But an inventor can only be a human being. So usually when a person is in employment under an entity, they assign their rights to the entity. It could be based on many factors, like, most of us, when we enter our employment firms, we always, have to sign a contract where we say that, when we invent something or come up with something new while in employment, using the resources of the organization, the right will belong to the organization. So basically something like that. So the inventors will have to assign their rights to the applicant. Form 2 is where you have all the specification details of the invention, where we'll have the detailed descriptions of the invention. You will also have claims, you have the abstract, you have the drawings, you have the summary, you have the title of the invention. Everything you will have in Form 2. Then there are other forms like Form 3, where you are supposed to disclose the details of other inventions, not other inventions, same inventions or similar inventions which you have filed in other jurisdictions. Let us say, for example, there is a US patent application and the US entity is interested in Indian market. Then they have to file an application in India. The US entity may also be interested in European market, Australian market, in South Africa, many other countries. So they will have the same invention filed in all these countries. So in Form 3, which we file in India, you have to give a detailed disclosure of which other countries you have filed the same invention in, what are the, application numbers in each of these countries, what is the filing date, and such disclosures are given in Form 3. Then there are other forms like Form 5 where the applicant declares that, sir, these people, the below listed people are the inventors of the application, and such forms are, so there are about 31 forms for patent. So there are for various activities. Then coming to examination, once you have filed a patent application, once a complete specification is filed, automatically the publication will happen in 18 months. So only after 18 months, after the publication, the patent will be taken up for examination, and also only if you have requested for examination. So it's not just because you have filed a patent application does not guarantee that the patent application will be automatically examined. You have to also request for examination. And this request has to be filed within 31 months. Beyond 31 months, it will be considered as abandoned. Even if you have not filed a request for examination after 31 months of filing a patent application, it will automatically be abandoned. So examination happens after you request for examination, and it usually goes into a queue in certain domains. So there is chemistry, there is mechanical engineering, there is biochemistry, medical devices. There's many domains, and each domain have many patent examiners. So it will go into a queue, and it will get examined. The examiners will look at the novelty, inventive step, and initial applicability, and they will also look at the Section 3. I talked to you about the non-patentable clauses. So if it comes under any of this, and they will issue a first examination report. And once this is actually the prosecution stage. Once the examination starts, the prosecution starts. So if the examination after the first examination, they will issue a report, and you have to submit a response within 6 months. So if you once you have submitted the response for all these objections, and if the controller is satisfied with your responses, then patent will be granted. If he is not satisfied with the responses, then he or she will give you a hearing notice where the outstanding objections will be mentioned, and you have to attend a hearing. Usually nowadays it is all happening through video conferencing mode, and the controller and the applicant or the applicant's agent will sit and discuss the outstanding objections and try to overcome these objections by various means. So basically, once all these prosecution is over, the patent will either be granted or refused. The controller is satisfied that all the criteria is met, then he will grant a patent. If it is not met, then he or she will refuse the patent. And once patent is refused, you can always go for appeal, and there are other methods by which we can still see if there is a possibility to revive it. So coming to the next slide. Types of patent application. I think this is something which I have already covered. Provisional application, and basically you can secure an early filing date with it, and you need not disclose the entire invention here, because you might still be working on the experimental details and such things, so you might still be fine-tuning your invention. So you need not disclose the entire invention, but the crux has to be there. And once you file a provisional application, you have 12 months from that date to file a complete specification. So these deadlines are very strict in patent. If you cross the deadline and if you have not taken an action, then it will be abandoned. Complete specification has all the details of the invention. It will have drawings, it will have claims, it will have detailed descriptions of the invention, or examples to substantiate your invention. All these things will be included in a complete specification. Then convention application and PCT application are international applications. So you have an Indian patent and you are interested in European market, you are interested in US market. So basically you have, I'm just giving two examples. There are many companies which file, for example, if you look at Biocon and all, I'm sure many of you would have heard about this company. So they have extensive market. They come up with drugs, for diabetes and all. So, their market is really huge. It cannot be just US and Europe. So they file extensively across the globe. So how do they do it? So they basically might have, if the Indian entity has developed something, then they will have an Indian application based on which they enter all the other jurisdictions. So as I told earlier, novelty is an absolute criteria. So if you have already filed in India, and let us say in another 1 month or 2 months you're filing in US, it will not be novel because of your Indian application, right? Because you have already disclosed in India in 1 month before. So I'm so sorry. So so because you have disclosed in India before, your novelty will be killed basically. So this convention application is basically Paris Convention application, and PCT is Patent Cooperation Treaty. So both of these are treaties where, in Paris Convention Treaty, you have more than 190 countries as signatory. And in Patent Cooperation Treaty, you have close to 160 countries as signatory. So if you have filed an first application in any of these countries, and if you can file a application, if, let us say if it is a PCT application, if you file one single PCT application with the International Bureau, that is World Intellectual Property, which is the one which PCT is basically governed by the World Intellectual Property Organization. If you can file one single application with the World Intellectual Property Organization PCT, then you will automatically have the provision to get protection in these 160 signatory countries. And in convention application, there is no such middle entity. You can file in any of the countries within 12 months and you will be protected because of the clauses in the treaty, where it says that somebody who has filed an application in a signatory country can file an application within 12 months in any of the other signatory countries and get the same priority date that they had in the first file country. So that is basically what these treaties cover, so that you get protection wherever you want to. Next slide is patent examination process. So this is something I already covered. So patent examination, you have to file a request for examination. Without this request, they will not take it up also. And it has to be filed within 31 months. And the patent examiner will examine the application. They will check for novelty, inventive step, industrial applicability, and whether the invention comes under any of the non-patentable clauses. And then they issue a first examination report. So in this first examination report, they will state all the objections they have regarding all these criteria which was mentioned earlier. And the applicant has to respond. And if there is any amendment that has to be made to the claims or to the specification, to the drawings, anything, the controller will indicate those things in the first examination report. So it has to be done and the response has to be submitted within a stipulated time. And then, either it goes for a hearing, or if the controller is satisfied, she will grant you a patent. So the final decision is made to either grant a patent or to refuse a patent. The next slide. Let us say, and I already discussed before that when it comes to analysis of novelty and inventive step, checking these criteria, you are limited to the resources that are available online. And even those resources that are available online, it is there are chances that you might miss on relevant documents, because the number of documents that are available are in millions and billions. So it is humanly impossible to assume that you will be able to cover all these documents. So therefore, there is a provision in the patent law where oppositions and revocation proceedings can also take place. So let us say you are an entity who works in gypsum boards, and you have got a patent. Now, now that you have got a patent, you feel that your competitors are infringing your patent rights, and you have sent them notices saying that you are infringing my patent rights, so don't make it, don't use it, because I have the right. So what does the other party do? They, if there is no provision in the law to, that the aggrieved party can take up an action against that, then, it is very difficult for the other party, right? So therefore, there are proceedings such as oppositions, which could be a pre-grant opposition, it can be post-grant opposition, it can also be a revocation proceeding. So what is a pre-grant opposition? Pre-grant oppositions are oppositions filed by interested parties who do not want this patent to be granted because of various reasons. There are, basically, if you look at the patent law, it gives you certain grounds. Grounds for opposition and for pre-grant cases, and grounds for opposition under post-grant cases. So one of these grounds has to, just because you don't like that cannot be a reason. There should be valid reasons why the patent should not be granted. So these grounds are, invoked, and we can file a proceeding to oppose a patent grant. And revocation proceedings are ones when, post-grant opposition, usually there is a time period. It can only be filed in 1 year time. After the patent is granted, within 1 year, if you can initiate the post-grant proceedings, it will happen within the patent office or the intellectual property office itself. But after 1 year, and there is some dispute between the patent holder and an interested party, then revocation proceedings can be taken up in a court of law. So coming to patents, rights and durations, patent, the term is for 20 years, and the person who has a patent has exclusive right to make, to use, sell, distribute the invention, and to, license or assign the patent. So whoever is the patent holder has the right to do all these things. They can license it out, and they can give exclusive licenses, non-exclusive licenses. Exclusive licenses where you exclude everybody except one person, or non-exclusive licenses where you give license to several parties to make, use, sell, distribute the invention. And patent holders usually get a margin in the profit. Then maintenance. Maintenance is another thing, whenever you have a patent, it is important to maintain the patent by renewing there is an annuity fee where every year you have to pay a certain amount to the patent office to maintain the patent. So if you do not pay this fee, the patent will lapse and it will come into public domain where anybody can use it once it comes to the public domain. So to avoid that, you have to always maintain the patent by renewing it by giving the annuity fees for a period of 20 years. So what are the common pitfalls in patent filing? Basically, not looking at the prior art to make sure your invention is novel and inventive. This is one of the common pitfalls that we often come across in patent filings. So people often file for patents, but they lack novelty and inventive strength. So that is one thing. Incorrect drafting of claims. So when claims are drafted in a certain way, it is a techno-legal document, and the wordings and the specification, especially the claims are drafted is something, more legal and has the technology aspect. So if the claims are not properly drafted, then the patent office cannot do much. Whatever you claim, you get only grant for that. If you have not claimed properly, what will they grant you? So to draft the specification correctly, to draft the claims correctly is a very important criteria. Then another pitfall that we often see is people often file patents, but they do not know that, they also have to file for request for examination. Certain actions have to be taken within timeline. So they do not know these things. Because of these delay and not knowing, the act will also cause the application to be abandoned. Then another, pitfall we often come across is non-compliance with the provisions in the act. So the patent law says that, I'm just giving one example. Apart from, doing actions within the timeline, there are provisions where working statements of patents have to be filed, annuities have to be filed. So people who are new to the field or who do not know what the act or the rules mandate, they will often not know that actions have to be taken. So working statements are, mandatory documents which has to be submitted once a patent is granted. So we have to keep informing the patent office whether we are working the invention or not. So if not doing these in timely manner will attract many, legal provisions. Punitive provisions have been taken away nowadays. But otherwise, if not filing a working statement can give you a fine of rupees 10 lakh and all. Those provisions were there till a few, probably 1 or 2 years back. So non-compliance of provisions is a very common pitfall we often come across. Another thing is the provisions under the Indian Patent Act. So non-patentable inventions, which I have already discussed. Then there are inventions which, when it comes under, like, let us say, atomic energy based inventions and all that, such inventions are not patentable under Section 4. Then restrictions on foreign applicants. So, restrictions on Indian applicants basically. So if you are an Indian applicant, you have to, and you have conceived the invention in India and developed it in India, then it is a requirement that you have to file the first application in India. If you do not want to file the first application in India, then you have to take permission from the Indian Patent Office to first file it in a country other than India. So these are provisions which are very strict, and it has consequences if not adhered to. And there is another interesting provision in India is the compulsory licensing. Many of you might be familiar with it, especially when COVID was there. When COVID was at its peak, this one provision was very much a focus of debate in many debate sessions, where life-saving drugs has to be compulsorily licensed. So what happens is, let us say one company has a drug to have a life-saving drug for COVID, but for various selfish reasons, they do not want to give licenses to everybody so that a national emergency is met. So when such emergencies arise, the government has a provision that they can invoke this compulsory licensing provisions to make sure that the drug is licensed out to as many parties as possible who has the infrastructure to come with such drugs and bring it to the market so that people's lives are saved. Then recent developments in patent law. So as I said, there are many amendments in patent laws. So basically, these amendments are focused on improving the business, improving the formalities requirements part in the patent office to reduce the bureaucratic, red tape, the delays, all these things. So there are many provisions which has come up, and there are also provisions, initiatives such as Startup India, and to encourage small entities, the government has reduced the fees. In the past 1 or 2 years, they have reduced the fees for startups. They have, in fact, startup was brought into the provision of, provision of the patent law. Then small entities had reduced fee. Then female applicants also had some benefits, like they could expedite the application. Certain entities were allowed to expedite the application so that their patents get granted as soon as possible rather than taking the normal 3 to 4 years time. So there are many provisions that has been amended through the patent rule to bring about ease in many aspects of the patent system. So this is actually the e-portal through which we file the patent. So here you can see you have a username, password, and only agents can use it, and also regular filers. If companies are regular filers, they can also use it, but basically agents will use it. Here you need a digital signature. So if you look at the right hand side, you can see information instruction, right? There you can see new to e-sign. So it's new to DSA, digital signature. Digital signature is mandatory to use this site. So apart from having a username and password, you should also have a digital signature to use this website, so that all the documents are digitally signed. Whenever you sign for your clients, basically as attorneys, whenever we sign for our clients, we have to have these have a digital signature and an account in this e-portal. And this is just the first part of the patent fee structure, where in entry number 1, you can see the fees for applying a patent. So if you look at the middle portion, you see that what is the fees for e-filing and what is the fees for physical filing. So I think from around 2016 onwards, government started incentivizing e-filing rather than physical filing. They do not want to accept physical documents. They are happy with digital documents. So around 2016, they made it mandatory for all the agents to only file through electronic portal and not file through physical mode. And also, if you look at the fees for e-filing and physical filing, can you look at the difference? If you are a natural person, the fees is 1,600. And if you are doing e-filing as a natural person, if you are physically filing as a natural person, then it is 1,750. Similarly, if you are e-filing as a large entity, your fees is 8,000. But if you are physically filing as a large entity, it is 8,800. Here you may find that it is hardly a small difference. But if you look at the fees for expedited examination and all, difference is really huge. So therefore, to encourage electronic filing, government has given a reduced fee schedule. Also, government has brought the startups, small entities, and educational institutions under the natural person fee category. So natural person have the lowest fees initially. Initially, there was only large entity and a natural person. So any company had to file as a large entity where you pay 8,000. But now startups or small entities or even educational institutions have been brought under this natural person, where your application fees has come down to 1,600 from 8,000. 8,000. So this has been done keeping in mind that to encourage inventions or innovations coming from educational institutions, research institutions, and such, such spaces. So to conclude, patents are, necessary because they foster innovation, they create economic value for the creator, and they help in protecting intellectual property. And, you have to, if you are a practitioner, if you have patents, if you are a creator of innovation, you have to be updated about the changes or the amendments that are happening in the law. And we suggest that it is always better to seek professional help, because maintaining the timelines and taking actions in a timely manner is very important when it comes to safeguarding your innovation. And a professional who does it on a regular basis will know what actions to be taken at what point, so that your intellectual property is safeguarded, so for a smoother filing process. Basically, that concludes my presentation. If anybody has any questions, please ask.
Hello, madam.
Hello.
That was a very crisp and very informative presentation, madam.
Thank you, sir.
Madam, I have a doubt regarding the provisional specification and complete specification.
Yes, sir.
Suppose I have filed a provisional specification, and what are all changes I can incorporate in that provisional specification within the 1 year. After that, I have to file a complete specification also. So what are all changes is possible? Can we change the title, abstract, or can you give some light on that?
Sir, when you file a provisional specification, you must have completed some 60-70% of your work. Okay. So at that time, you know what your product is, you know the direction in which this is taking, but you may not have, certain substantiating evidences. Let us assume it in the context of a chemistry experiment. You have come up with a, let us say, pesticide. You know that it is working, but you still need to work on certain experiments to, let us say, identify what is the lethal dose of this, what is the minimum dosage that is required. I'm just giving you an example, sir. So you will still need those details, to be filled in. So, but you still have your pesticide and you know it works. So at that stage, you can file a provisional application where you give a detail on what is your pesticide, what are the contents in your formulation, what is the approximate ranges. You might be able to fine tune when you file a complete application. But in your provisional application, you can give all these details with the broadest ranges and file a patent application. In your complete application, you will disclose, what is the reasonable range. Let us say you have taken endosulfan and one or two other components. So endosulfan in what range? 1 to 2 ppb range. In component A in 3% range. Component B in 10% range. Those specifics you will be giving it in your complete specification. Also, all the experimental data where you say that in this range endosulfan is not harmful to certain organisms, but it does the job. So those kind of details and all you will give in the complete specification.
Madam, that means we cannot change any claims once that we have given in the provisional specification. Am I right?
No, you do not give any claims in the provisional specification. Claims will only be part of a complete specification.
Okay. So what are the things that should be given during the time of provisional specification?
So if you look at the same example, what are the components of your pesticide and approximately what is the ratio of each component? What does it act on? Let us say it is an antifungal agent. So what are the various fungal diseases it acts on? There are many fungal diseases that affects plants, right? So let us say, fungal disease A, fungal disease B, these are the fungal diseases. Basically, that is what you will state in your provisional specification. So there is a technical problem where, certain fungal disease is causing havoc in, let us say, paddy cultivation, and you have come up with a pesticide which is not harmful to the, not as harmful to the environment or to the crops, but it is working on the fungi. So you have fine-tuned the composition in a bigger, composition with the higher ranges. It might be harmful to the environment, harmful to humans also. But you have come up with a composition which is not harmful, not as harmful, but it also does its job. Yeah.
So that means for professional specification, we don't want any claims. That is only given during the complete specification.
Not just claims, you may not even have all these experimental data in a provisional specification.
Okay. Madam, one more doubt. You told about the inventor and the applicant. Okay.
Yes, sir.
So normally in education institutions, the applicant will be the institution. Okay.
Yes.
So when the patent is granted, will the applicant's name will be in the grant certificate, or the inventor's name will also be there in the grant certificate?
Applicant is the owner of the patent. It's not the inventor. So applicant's name only will be so and so patent has been granted to so and so. That is all will be there in the patent certificate.
Yeah.
If
So
you
applicant's name will be only there in the patent certificate.
No, I'm still not finished. So if you want the names of inventors to also be included in the certificate, there is a form which you have to fill along with a prescribed fee which you have to pay. If you file the form with the fee before the patent is granted, they will include the name of the inventors also. But if you do not file this fee or do not file this form, then the normal patent certificate will not have an inventor's name.
Okay, I got it, madam. Got it. Okay. Thank you, madam.
Oh, thank you, sir.
Any other queries from the participants? Now the floor is open for clearing your doubts. You can also enter your doubts in the chat box.
So I have also shared my email ID and our firm's address, phone number. If you have any questions, if you have any requirements for any intellectual property related aspects, you can always call us or write to us.
Okay, madam. Thank you.
Okay, thank you, sir.
Vandana, are you there?
Shall I leave, sir?
Please wait, ma'am.
Okay.
Vandana?
Yes, sir.
Yeah. Please go ahead.
Sir, Ramisa is saying the vote of thanks today.
Hello?
Sir, can you hear me?
Yeah.
Sir, Ramisa is saying the vote of thanks.
Yeah. Then where is she? Please.
Sir,
Yeah.
good evening, everyone. On behalf of all participants, I sincerely thank Ms. Dhanya Ramachandran for her insightful session on patenting system and filing procedures. A special thanks to IPR Cell, TKM College of Engineering for organizing this valuable workshop. We also appreciate the effort of all coordinates for ensuring a smooth session. Finally, thank you all attenders for your active participation. Also, kindly fill the form shared in the chat for marking attendance. Thank you.
Okay. So please wait here for 2 minutes. I want to say something regarding the future work of IPR Cell, TKMCE. So by the next month, we are planning a